Hello, my name is Zach McGee. I am the chairman of New Media Legal Publishing, the sponsor of the CLE program you are about to watch. This program was recorded a few years ago, but we've confirmed that the content is still current and reflects the present state of the law on this topic. I hope you enjoy it.
Hello and welcome. I'm Peter Afrasiabi, a partner at the law firm of One LLP with offices in Newport Beach and Beverly Hills, California. Today's program is Caught on Tape, Deposition Disasters. This is going to be a fun walk down the path of what can go wrong in depositions and the melees that can ensue as a result. And if you're videoing your depos, what happens when you get caught on tape or your clients get caught on tape creating problems. This is a great primer overview for litigators, young litigators, old litigators, to see how things can unfold and go wrong when we're using video. This is also great fun for those of you who are not even litigators. You may be transactional lawyers or general practitioners, and you just want to have a relaxing, fun CLE where you get to watch some deposition disasters. So let's get going and see what happens when you get caught on tape.
Did you talk to this man sitting next to you before this deposition started?
Yesterday, but he had nothing to do
I
with
didn't
what
ask
you
you
are
that.
currently saying. I said it, though, didn't I?
Did you talk to him, sir? What did you say?
I said nothing. I said, you have a case of incipient verbal diarrhea.
Oh, sir, we're going to see about that.
Well, good.
Did you talk to him yesterday?
Yes.
How long?
About 3 hours.
Talk about this case?
Yes.
Did you tell him the other companies you consulted for?
No. I did
You're
not.
under oath here.
I did not.
We'll see about it. When you were at Monsanto, what was your title?
At Monsanto, what do you mean?
In Texas City.
Research chemist.
And was that your title during your entire stay at Texas City?
Texas City, yes.
Don't talk over each other.
After you left Texas City.
Wait a minute, let me ask a question here.
Yeah.
You represent this guy or not?
Who are you?
My name's Tucker, and I represent Ayrshire, and I just want to know, do you represent the guy or not? I'm getting, if you don't represent him, you don't have any right to be making any objection. If you do represent him, tell us so.
Why don't you keep your mouth shut? I'll do what I want.
No, you're not
Hold
going to do
it.
what you want.
Oh,
I'll
wait.
do what I want.
No, you're
No,
not.
you're not.
Yeah, I am.
That's
I'm gonna make
bullshit.
whatever objections I want to make, and I'll make them as loud as I want to make them. Now you just shut your mouth, and we'll keep the record straight.
Don't tell me to shut my mouth, boy. You may be big, but you want to see how bad you are? Come on.
And I wouldn't try that, Ed.
Are you threatening to fight?
Hold on just a second.
No, I want to know whose side we're on. We're going to be outnumbered, Ed.
Hold on just a second.
No, you got a big mouth. Now, you do. Now, you need to either represent the man or not.
I'm
I've tolerated
representing Monsanto, and I'm
But
making
you're
an
not-
objection on the record.
Then you're not entitled to be his lawyer then, okay?
I'm not representing the man.
Well,
I'm
you're
making
trying
an
to be.
objection on the
And
record.
another thing,
Don't tell
you
me what
don't.
I'm trying to do.
Yeah, I'm going to tell you something else. You don't run this deposition. You
Neither
understand?
do you, Joe.
You
Neither
watch and
does
see.
he.
You watch and see who does, big boy.
I'm telling you, Joe.
No, you ain't telling me a goddamn
I'm gonna make
thing.
whatever objections I want.
You
to
can make your objections and
You can
keep
talk as
keep
loud
quiet.
as you
See,
want. No,
but
I'm
don't be
not
telling
gonna
another
be
lawyer to
quiet.
shut up.
Don't be
That
telling
ain't
me
your
to shut
goddamn
up.
job,
No, that's
fat
not your
boy.
job.
Now
Mr.
get back.
Hairpiece.
Now you got
As I
time
said
to answer
before,
me?
you have an
Hold on just a
incipient
second.
bad
What do you
mouth,
want
don't
to do
you?
about it, asshole?
Oh, I'd like to knock you on your
Wait a
ass.
minute.
Come try it.
I'm not
Wait a
going to do
minute.
that.
Wait
Come
a
over
minute.
here and try it, you
Wait a minute.
dumb son of a bitch.
Wait just a second.
Come over here.
Hold it. Hey, wait a minute. Hold on.
close.
No way.
Get
Hold on.
close.
Hold on. Hold on just a second.
His associate are taking Mr. Garrett out in the hall to lecture him, I suppose. They're doing this over our objection. We started this deposition, unable to get an answer from this man.
So there you saw the first clip. That was quite a melee with these lawyers. We had fighting lawyers, fighting witnesses, threats, put downs, improper behavior by all. We heard cursing under the breath. We had someone calling someone Mr. Hairpiece. We had an objecting lawyer saying to keep the other person's mouth shut and they had no business being there. You had someone calling someone Mr. Big Boy, telling them, let's see how bad you are and let's fight. You had a lawyer calling a witness a dumb SOB, and you actually then had a literal fight erupting, as you saw. It was sort of everything that could possibly go wrong in a deposition in terms of everyone getting up to no good. This one has it all. So this could be the clip of all time when it comes to actual fights between lawyers and witnesses and what is fundamentally a deposition disaster. So now that you've seen that video, that can kind of give you a sense of where we're going today and the fun stuff we're going to look at and we're going to walk through so that we can all try to do our best to avoid having this happen to us. As we look here on the next slide, before we get to our full overview, I want to give you a quote from a court. And this is reflective really of where we are today in the 21st century in terms of judges and their tolerance for ill behavior of witnesses and lawyers. And here's the quote. Both sides have complained about opposing counsel's conduct during depositions. The court's extensive review of these pages serves as a useful reminder that loaded guns, sharp objects, and law degrees should be kept out of the reach of children. Both lawyers made inappropriate speaking objections to deposition questions and improperly instructed witnesses not to answer questions. This comes from the AG Equipment Company versus AIG Life Insurance case. This is from 2008. It's a district court decision of a judge who was reviewing a record and ended up sanctioning people. It doesn't relate to the video you just watched, but this is just a general quote that has come from a court, and I thought it was particularly well written in terms of loaded guns, sharp objects, and law degrees being kept out of the reach of children. And it reflects the judicial frustration at what can happen in the deposition process as everyone goes off with loaded guns and sharp objects and creates melees. Let's look at our next slide of the overview. Where are we going to go today then as we go through this caught on video deposition disaster adventure? We are going to get an overview of some deposition do's and don'ts. We will look at out-of-control lawyers, out-of-control witnesses. We will look at improper instructions from lawyers, that is, instructions not to answer questions in a deposition, when you can do them, when you can't, and we'll see some examples of when they're being done improperly. We will, of course, look at real-world deposition clips of these deposition debacles so that we can really explore and understand these rules so that we can both protect ourselves and our clients and be prepared to deal with them if we are on the other side of it. If we perhaps are the lawyer taking the deposition and being confronted with a witness or a lawyer who's behaving in these ways, we can pick up some do's and don'ts, some tips in terms of how best to handle and manage the unfolding situation, the melee. Here's a big tip: don't get in a fight. We're also going to look at tips as they relate to maintaining credibility, because one of the overarching umbrellas that this entire program sits beneath is the idea of credibility. And how will this witness look at trial if this video clip is played before the jury? And how could this damage your credibility in terms of your case, your client's case, if this unfolds in an improper way or in a bad way? And even if many of these clips may be the types of clips that, even if those cases that you'll see ultimately went to jury trial, those clips may never get shown the jury for a whole variety of evidentiary reasons. But nonetheless, these clips could easily find their way to the judge on a motion to compel at any time, and it could certainly color the judge's perspective about what is going on. And so maintaining the right witness demeanor and the right lawyer demeanor is particularly important to credibility, which is one of the massive themes. If you've watched my other programs or our other Curious Lawyer programs, you'll have seen our advocacy programs in terms of the central role of credibility from beginning to end of a case. And so a lot of this fits within that, and it makes it actually a particularly fun petri dish to get into as we look at all these deposition disasters. We will also then look at how one manages the celebrity client, the rich and powerful, the difficult client, the super powerful CEO, the mega celebrity. These are the types of people who are particularly difficult, it appears, to prepare for depositions, to make them understand the nature of this conversation that happens in a deposition and how different it is to the rest of the communication that we engage in generally, but also that they are used to. Especially our powerful CEOs, our business leaders, those who've built and are running large companies or even small companies, but they've built it from ground up. They and celebrities, they are often surrounded by an entourage of yes people. And they are not used to engaging in a dialogue like a deposition where they're a witness and they don't get to control who says what to them, how one speaks to them, and there is no filter on what they are being exposed to. And that can create consternation for these folks, given, I think, the normal way they live and what they're exposed to. And so it becomes a breeding ground in particular for depositions to unfold in a way where they ultimately provide testimony that is not the best testimony, I would think, that they could have given in order to maintain credibility for their case. And so this then becomes a lesson for us as lawyers in terms of what do we do to prepare them best we can. And maybe you can't ultimately prepare them fully, but you better have a letter to the client in your file advising them of what you've done to prepare them. And if they decide to go off the deep end, let them go off alone. Finally, we're going to look at sanctions and how sanctions can unfold because of misconduct of lawyers, misconduct of witnesses, and even how a lawyer can be sanctioned for not controlling his witness when the witness becomes too unruly. So it's really important to be well aware of how these things are unfolding in the 21st century, and courts are becoming more aggressive. Let's start on the next slide with a bit of a background in terms of depositions. And we're really in this program looking at the Federal Rules of Civil Procedure and some cites from California cases, and these are generally applicable rules that really govern in the entire nation. So they are of general applicability, and so you can run with them in whatever form you may be in. At root, discovery should be liberally construed in order to take the game element out of trial preparation by enabling the parties to obtain evidence necessary to evaluate and resolve their dispute before a trial is necessary. And this is just a general statement from a California practice guide, the Civil Procedure Before Trial by Weil and Brown. It's also reflected in California Supreme Court case Greyhound Corp. Versus Superior Court from 1961. It's an old California Supreme Court case that's still good law 70 years later. The other principle is that any doubt is generally resolved in favor of permitting discovery, particularly where the precise issues in the case are not yet clearly established. Similar cite, Colonial Life and Accident Insurance Company versus Superior Court, 1982 California Supreme Court case at 31 Cal 3rd, 785. Now we see on our next slide here that the scope of discovery as a result is very broad. Discovery allows people to inquire into material that is relevant to the subject matter, and that's broader than what may be relevant or admissible, that is, at trial. And so therefore, hearsay information can be discovered, irrelevant matters may be discovered if they may lead to the discovery of admissible relevant evidence. And you see a couple case cites there, Smith versus Superior Court, Dodge v. Riley, and those are very prototypical standard premises and principles. And so what that means, as you see as we're funneling in here, is that questions will be asked that may be frustrating, bothersome, irritating, irrelevant, inadmissible at trial, but they may be the types of questions that can certainly lead to the discovery of admissible evidence. And so this broad reach of relevance in terms of discovery filters into depositions and allows all manner of questions to be asked that witnesses often may not like or may feel troubled by, but nonetheless need to sort of be ready to engage with. And the preparation of the witness can be the biggest thing to get them ready for things that may be frustrating or bothersome to them so that they don't explode and erupt on the stage, as we are about to see. And so let's go to the next slide here, and we're going to talk out of the gate first about the personality client. Rich, famous, super powerful celebrities, and how we deal with questions about what is relevant, irrelevant, and improper and proper behavior by a witness and a lawyer. So let's take a look at this.
You got Selena Gomez? Yes. Were you dating her at some point in time?
What's the relevance of that? Why are you asking that question?
Because I'm allowed to ask.
No, you're not allowed to just make up stuff and ask it. What are you talking about?
It sounds like you're trying to harass him.
Be a lawyer, man.
Stop making
journalism. This isn't journalism.
What is the relevance? What's your pro offer?
Have you ever?
What's your
if
pro
you have an objection, state your objection.
What's your pro offer of relevance on that?
Sir, have you ever talked with Selena Gomez and discussed your feelings about paparazzis with her?
Don't ask me about her again.
Sir.
Move on to another.
Don't ask me about her again. Don't ask me about her again.
Have you ever?
Don't ask me about her again. Don't ask me about her again.
Wait, let's take a break.
You know what? Just stop.
We gotta take a break.
Don't ask me about her again.
We gotta take a break.
The client's not asking for a break.
Don't ask me about her again.
Let's take a break, Justin.
302.
So you saw there Justin Bieber, a couple minutes in that clip in the deposition that was being taken of him, and you saw his demeanor. He behaved in a way that in my opinion, I'd characterize as kind of being petulant, angry, borderline threats even. You had a lawyer complaining about questions being asked that were irrelevant and indicating that this isn't relevant and it's inappropriate. And you even had the one lawyer telling the other lawyer, quote, "Be a lawyer, man," end quote. These are the types of things that can fundamentally, in my opinion, damage your case as you're preparing your case, because all of this stuff will get before a judge eventually, and who knows, maybe before a jury. And if it goes before a jury and it were actually the type of stuff that could get before a jury, you've now got your client, who already will be predisposed to be viewed a certain way by a jury, appearing petulant, angry, borderline threatening, as you saw. And that's the type of stuff that could ultimately damage the case. I mean, the truth is, if Justin Bieber is going to trial, or any celebrity is going to trial, they want to appear calm, honest, polite, decent, upstanding citizens. They don't want to look like they are arrogant, over-the-top people who, fit the narrative of what everyone may think super celebrities are, who are surrounded by entourages of, handlers and yes people and the like. So it's a good example, I think, to look at. And it doesn't just apply to celebrities. We don't, not everyone watching this is going to be representing celebrities or super famous, but we all represent, even small businesses, people who have built their business from the ground up and they feel pretty important, feel good, pretty good, as they should. They're successful, they've done a great job. But in a deposition, it's a different format, and this is an example, I think, of why on the front end, if there's some preparation for these people to control and manage them, you can best make sure that what they provide is something that you ultimately want to show a jury. And it's particularly difficult for certain people, I think. As you saw there in the clip, what you can pick up is that certain people are not used to this format where they are the subject of an inquisition, a questioner who gets to control the narrative, control the dialogue, does not, the questioner gets to ask questions, questioner doesn't have to answer anything. Questioner gets to tell someone, answer, and they may not be used to being spoken to that way, and so it's an alien form of communication even for them, as it is for most people, really. And this is why massive preparation on the front end is one of the best things you can do. And of course, no doubt the lawyers did that, and one of the best things you can also do as a lawyer, in my experience, when you know you have witnesses who are difficult to manage and difficult to corral them into behaving in a way that you believe is best to protect their case and their interests ultimately, you have to send a CYA letter to the file, to the client, keep it in your file to protect yourself so that you are clear about what you have done, the preparation you've done with them, the review you've done with them, the discussions you've had in terms of how to behave, what not to do, how to behave, in other words, so that if it goes off the deep end and problems erupt, at least there's no boomerang back to you as the lawyer. So let's keep moving along here in our program today, and we're now going to shift a little bit to deposition objections. And now we're going to look a little bit at the lawyer. We saw a bit of in the last clip with the relevancy objection that was made. And we're going to talk about what types of objections are appropriate in depositions and what are not. And there's differences between federal and state court, and differences between states, and there's even differences between judges in the same state, frankly, as to what realm of objections specifically can be made or should be made. But the general rules here are as follows. And this is just the general rule, of course. Objections to anything other than form of the question are preserved, and objections to form need to be made in the deposition in order to preserve them. And so what that means is that if there's an objection to the form of the question, you need to make it in the deposition, otherwise, you may waive it. And so these are things, sort of along the lines that we have here. And like I said, courts will differ on some of these as to whether they agree or not that they're appropriate in a deposition. But at a rough level and a high level, it is objections such as compound, asked and answered, foundation, vague, ambiguous, calls for speculation, assumes facts, misstates testimony, privilege, argumentative. Those types of objections you need to make if you want to preserve them. Otherwise, you haven't made it and it's not preserved. And making the objection gives the lawyer asking the question a chance, obviously, to, if they have a problem with the question that there is there, they can fix the question and get at it. Now, other objections are not waived, and that means they don't need to be made in a deposition, and they really shouldn't be made in a deposition, is what most courts generally say. And that's things like relevancy, hearsay. You don't have to say that in a deposition, obviously, as I no doubt you all know as litigators, and non-litigators you may not know that. Those objections don't have to be made. If something's relevant or irrelevant, if it's hearsay or not hearsay, it's something that can be dealt with later at trial if that deposition clip is attempted to be put before the jury or the judge in a bench trial. Your objections are still preserved. someone, in other words, this goes back to what we said earlier, someone has a right to gather hearsay or irrelevant material because it may lead to the discovery of relevant material so that you can go speak to the person and so it would not be hearsay, for example, and you could nail down, if Jane says John said X, Jane can tell you that, it may be hearsay, but now you know John said it, you can go take John's deposition, no longer hearsay, right? That type of thing. Now, one of the issues that comes up is that if you are objecting to form, under the federal rules at least, you need to concisely explain it in a non-suggestive manner. And this is where there is really a line, and it creates a lot of what is often confusion between different courts and cases and judges, between different lawyers, and there's this sort of, I would call it this vast penumbra of grayness about what we can or cannot do, and it's very subjective, and it's very case dependent, and it's often dependent upon just the lawyers in the case on each side in terms of the currency of what we're all willing to agree to do in terms of how we each, treat each other's witnesses and depositions. But this line between simply saying objection to form versus I object, it's vague and ambiguous as to time, or compound, calls for speculation where there's more detail being given, that line between whether it's a concise explanation or whether it becomes suggestive is one that can trigger courts in different ways. And so as we're going to see in a moment here, we have some courts who, you may say objection vague and ambiguous, and a court can feel that's being too suggestive. Other courts would say, no, it's not. And so this creates problems for us as lawyers, obviously, in terms of taking depositions, and we want to recognize that these lines can be murky, and we need to be very, very careful and think very carefully about what we are going to say or not say and whether we are being too suggestive in a way that's inappropriate. And so let's look on the next slide here at some cases that have held that object to form is insufficient to preserve the specific objection. And so this would be where you want to be careful and not be suggestive, but you say object to form and nothing more, and the court then later on faults you for it, right? We can't win, it turns out. And so here you have a couple cases and a couple quotes. Objecting to form is like objecting to improper. It does no more than vaguely suggest that the objector takes issue with the question. It is not itself a ground for objection, nor does it preserve any objection. If a question is propounded in an improper form, the objection should be stated concisely, on the record, during the deposition, in a manner that provides the questioner with a reasonable opportunity to correct the form. Failure to do so waives the objection. And so you see that coming from a couple cases. I mean, one's in Iowa, National Bank of Sioux City, Iowa versus Abbott Laboratories from 2014. One is Henderson versus B&B Precast and Pipe, and this is from the Middle District of Georgia, also in 2014. And that's an example where, the lawyer said object to form, maybe hewing too close to the safe line, and ended up not giving enough information and not really preserving any objections. Now let's shift on the next slide here and look at the interplay between these rules where it can, boomerang and go the other way when one says more. And we'll start with the federal rules. Although Rule 30 clearly commands lawyers must state their objections, quote, concisely in a non-argumentative and non-suggestive manner, end quote, Rule 32B, DC3B says, an objection to an error or irregularity at an oral exam is waived if it relates to the manner of taking the deposition, the form or a question or answer, and is not timely made during the deposition. So the solution from some courts to deal with this interplay between make your objection in a non-suggestive manner and avoid waiving it is that, quote, such an objection to avoid a suggestive speaking objection should be limited to an objection, quote, to form, end quote, unless opposing counsel requests further clarification of the objection. So needless to say, you can see there's a complete conflict between that principle from this case, which is Cincinnati versus Serrano, and this is a Kansas Federal District Court judge in 2012. Similar case from the Southern District of New York in 2005. This is Druck Corp versus Macro Fund, and there the judge said any objection as to form must say only those 4 words unless the questioner asks the objector to state a reason. So there you have courts saying you say more than objection to form, you have a problem. And if more than that is to be given, the lawyer hearing the objection needs to tell you, well, what do you mean? What do you say? Tell me something specific. And then you can say vague as to time, argumentative, compound, whatever it may be, right? Speculation. The prior cases we saw, though, courts are going the other way and saying that is not enough to preserve anything. And so this creates real tension, actually. And at least anecdotally, I would say my experience as a practitioner here in the state and federal courts in California and depositions really around the country, it's very rare to have lawyers object and say only object as to form. It's incredibly rare, actually. Texas, actually, there are some local rules in Texas that demand it too, so that may be a very different practice. If one practices there, I don't practice there. But the general currency tends to be lawyers give a little bit more. Speculation, vague and ambiguous, those types of objections. And sometimes lawyers say a lot more and they give long-winded explanations, and that'll trigger debates and discussions with respect to now you're coaching the witness or being too suggestive. But a few more words than object as to form is generally how things tend to occur, at least in most courts. Now let's look, before we get to a few more videos here in a few minutes, we're going to shift in this module to instructing witnesses not to answer. And here we're going to look at the Federal Rule of Civil Procedure 30, which is similar to the California Code of Civil Procedure at section 2018.010 through .080. But the Federal Rule of Civil Procedure encapsulates a general rule, and it's as follows. An objection at the time of the examination, whether to evidence, to a party's conduct, to the officer's qualifications, to the manner of taking the deposition, or to any other aspect of the deposition, must be noted on the record, but the examination still proceeds. The testimony is taken subject to any objection. Important line. The testimony is taken subject to any objection. An objection must be stated concisely in a non-argumentative and non-suggestive manner. A person may instruct a deponent not to answer only when necessary to preserve a privilege, to enforce a limitation ordered by the court, or to present a motion under Rule 30d3. So that's super important. And what the rule is saying is that the only time you can tell a witness, I'm instructing you not to answer, is if it is invading the attorney-client privilege or some other privilege, if it's in violation of an already existing court order in terms of the scope of testimony, or if you're going to instruct the witness not to answer so that you can suspend the deposition, you go to court to get a protective order, and you put it before the judge. But you can't just say, I don't like what's being asked, I think it's totally irrelevant, it's totally unfair, I'm going to instruct you not to answer. The witness refuses to answer, and then just continue chugging along in the deposition. And all of us who've taken depositions, that's happened to us many times, I'm sure, as we've seen, and it is improper conduct to instruct not to answer unless you do it on a legitimate basis as outlined here in the rule. And that is a general rule across the country in all forums. And so here we have a good quote from a case. This is Stewart versus Colonial Western Agency. This is a 2001 case from California, from the California Court of Appeal. It's reported at 87 Calap 4th, 1006. And here we have an attorney instructed his witness not to answer on grounds that the information sought was not relevant. And so this went before the court on a motion to compel, and the court ordered, quote, "You are ordered not to instruct the witness not to answer a question during any deposition in this case unless the matter is privileged. The proper procedure is to adjourn the deposition and move for a protective order. You don't assume the role of a judge and instruct a witness not to answer the question at a deposition. That is a big no-no. And as a result, sanctions followed." And that's the general rule. So now, let's take a look on the next slide here as we're going to watch another clip.
Do you think that there's anything wrong with adding testmaster students who you met only by virtue of your employment at Testmasters to a prospective client file for your competing company?
Would you read the question back, please?
Now, do you think that there's anything wrong with adding Testmaster students who met only by virtue of your employment at Testmasters to a prospective client file for your competing company?
An object to the question is no foundation. It calls for speculation, seeks a legal conclusion, it's argumentative, and I'm instructing the witness not to answer.
Mr. Tatey, do you think that it would be improper for you to copy your employer's course material while you're a Testmasters instructor and use it for a competing business?
Same objections, same instruction.
So as we sit here today, you don't know whether or not it's a true statement that as of March 30th, 2005, Blueprint had not yet finished the writing and production of its LSAT course.
Objection, argumentative, also invades the attorney-client privilege and the work product doctrine, instructing not to answer.
Do you deny, Mr. Tatey, that as of January 12th of 2005, that Matt Riley was a Blueprint partner?
Objection, same objections, same instruction.
Mr. Curry, this goes to the very heart of the case here, and I'd ask you to reconsider your instruction and allow Mr. Tatey to answer this very simple fundamental question.
I've reconsidered. The answer is no.
Can you rule out the possibility that Matthew Riley was a Blueprint partner while he was still teaching for Testmasters?
Same objection, same instruction.
Do you deny that Matthew Riley was a Blueprint partner at the same time that he was teaching Testmasters classes?
Same objection, same instruction.
Do you deny that Matt Riley was working on the Blueprint website while he was still teaching classes for Testmasters?
Objection, it's argumentative, calls for speculation, there's no foundation, instruct the witness not to answer.
And there you had it on that clip. That was a lot of instructions not to answer. None of them were on the basis of privilege. They were just on the basis of, speculation, foundation, whatever. That was a solid 2 minutes, as you saw, of a lawyer engaging in objections that under the federal rules would not be appropriate, and if it got teed up before a judge, it would get bad for the lawyer, no doubt. So that's a good example of where a lawyer is drawing a line that doesn't make any sense. If that lawyer genuinely felt that this material was improper for some other reason and was sufficiently far afield from the case that it wouldn't be appropriate, the proper mechanism is to adjourn the deposition, suspend it, go right to court. In some forms, you can even call the magistrate on the spot and try to get the judge on the phone to address it, but to go to court to get a protective order and air it out before the court, as opposed to engaging in that. Now let's shift. On our next slide here, we're going to talk about preparing the witness to handle the tough questions. And this time we're going to look at another fun clip, caught on tape again, of what happens when a witness is getting questions that are central and relevant to a case and perhaps hasn't been prepared enough by the lawyer and ultimately loses his cool and explodes and goes off the deep end. So let's watch this.
Don't nail me on that.
Did you obtain prior approval from the association for that shed?
Actually, I'm assuming you people have gone to the files, the building files, and all the other necessary files. If you haven't, you're a fool. Actually, it was an accommodation that we spoke about, and we never made it. It was an accommodation, and we never made a formal application about it. And if you take exception to it, I'll put it back where it was, which is right on the killer's line. You want me to do that? I'll be glad to. Today, tomorrow, next week, that's where it was. It was on the survey. It's on the survey. And I gently removed it. Am I going to be punished for it? Good. I'll put it back.
Was that a yes or a no?
It was a fuck you. What's your question?
There you had it. That was a tirade, and that was a witness who you could see in answering the question was getting worked up and worked up and worked up and then exploded with profanity. And that is the type of thing that you do not want to have happen at a deposition. It'll get before a judge eventually, and it'll lead to sanctions, no doubt, for that type of behavior. It's also the type of thing that if put before a jury could ultimately damage your case because it shows, it may just well damage your credibility, and it can show a whole bunch of different things to a jury that you wouldn't want to telegraph. The frustration may be legitimate, the person may be right, they may be wrong on the merits of what the question is, but that mode of speaking never works in litigation, in a case, in a deposition, and it always inures to your detriment. And the lawyer taking the questions will often, no doubt give a long rope to someone like that and hope that they hang themselves by behaving that way. So that's a great example of how things can go wrong if you don't really prepare the witness, you don't know what the witness's demeanor is going to be, and you don't go through some tough questions with the witness and get the witness in a frame of mind to a point of understanding that he needs to keep his cool and stay calm and not end with an answer saying F you, as you saw there. Let's now go to the next slide here, and this, again, we're going to look at the issue of preparing a witness to handle the tough questions, and we're going to look at sort of an example here of what it's like in terms of the demeanor. And so I want you to watch this clip and keep in mind, what would you as a juror think about this person in a case? I mean, you're a juror, you're being asked to take time out of your life, away from your job, away from your work, to come to court and give up your life to decide a dispute between party A and party B that's so important that it's dragging you out of your life and it's taking up our taxpayer dollars in this judicial court system that we have. And when you're pulled in as a juror, you expect that the people there have a legitimate thing to discuss and that they're going to take this matter seriously because they're demanding this be heard in court. And so that's the mindset, right, of what's going on in a court system. So let's watch this clip.
So do you have a position with All State Services Limited Partnership? Do you?
Yes.
And what's that position? Can you answer that question?
I'm going to answer it in just a minute.
If you know the corporate structure, you can testify to it. I ask you not to speculate, though.
I believe I'm just listed as a partner.
And as a partner of All State Services Limited, what do you do?
Just oversight.
Oversight of what?
Operations.
And what are the operations of All State Services Limited?
And I need a timeout for a minute. I'm sorry. Sorry.
You're back on the record.
You don't recall how long ago? Is that a no?
No.
How long has...
So there you had it. It was sort of a perfect example, I think, of what's really horrendous demeanor for a jury if a jury ultimately sees this, because there is no way that a witness sitting at counsel table while the jury is impaneled over there to the right, the judge is in front of you, the lawyers are there, there's no way a witness is going to be ignoring and laughing, rolling eyes, making faces, doodling, face smirking, all that stuff going on you would never do in front of a jury because it's silly, it's childish. I mean, it telegraphs to the jury everything you would never want to telegraph. But when you're doing it on tape in a deposition, you are doing it to the jury because that clip could very easily end up being played to the jury. And so that's a perfect example of how, however frustrated your client is, however meritless the lawsuit is, however frivolous it is, however stupid, inappropriate, crazy the other side is, you want to show up and always present your witnesses professionally and properly, and not like that. Let's keep going, and we're going to now talk again about the personality client. And here we're going to look a little bit at, again, the rich, the famous, the celebrity, the powerful. And this is a clip where we're going to look at in terms of some witnesses can ultimately be their own worst enemies because of the way they decide to present, when there's no reason that if they had just been taught to behave differently in a deposition, they could have done something completely differently. And so here we're going to watch the famous musician Lil Wayne, and we're going to watch a clip for a few minutes here. So let's watch it.
Clearly, Lil Wayne answers to no one.
Is that an interview that you actually gave with Katie Couric?
Is that an interview that I actually gave with Katie Couric?
Yeah.
What's your name again?
Hey, well, that's not the question.
What's his name?
Pete Ross.
Huh?
Pete Ross.
Pete Ross.
Yeah.
That's a stupid-ass question. You just saw me on there giving an interview with her.
Okay. So that was you. Did you perform at the Virgin Mobile Music Fest in 2008 with Kanye West?
I don't know, but I know I did perform at this badass bitch birthday party recently. She was crazy, stupid thick.
Isn't it something that you would remember if your album, The Carter 3, was the biggest selling album of the year in 2008?
Isn't it something that I would remember that?
Yes.
Isn't that a personal opinion type question? That's why I got that. I mean, because I would be actually answering the question to, isn't it something? That's my question. Isn't it something?
That you would remember.
Isn't it something? That's the question I have to answer, Your Honor.
Go ahead.
Isn't it something?
You could do the best trying to answer it.
Yeah, it's something out of your ass. That's my answer. Yeah, it is something out of your ass.
Have you ever hired a photographer to photograph an event?
Have I ever hired a photographer to photograph an event? Sorry, sir, no, I'm a superstar. People hire them themselves to photograph me. We don't hire them.
How would you describe your image in the media?
How would I describe my image in the media?
Yes.
I wouldn't describe it.
Well, how would you describe it if you had to?
I don't have to.
Well, what image are you portraying in the media?
I don't portray anything. I am who I am, and you guys portray what you get.
No, who are you? Who is the real?
I am Dwayne Michael Carter Jr.
Okay. Do you like to portray yourself as?
I just answered that and said that I don't like to portray myself as nobody.
Okay.
I completely be Dwayne Michael Carter Jr. I don't portray myself as anything. An image is self-described.
Well, you have to wait till I'm done with the question.
I don't have to wait to anything, honestly. I mean, this guy right here may tell me that I have to wait, but personally, I don't have to do nothing.
Go ahead, ask the question.
Thank you, Your Honor. Do you like
He can't save you, right? In the real world. That guy right there. He can't save you in the real world. Just so you know.
What does that mean?
I don't have to elaborate.
That's your next question.
Is that a threat against
me?
Mr. Ross, can you just ask your next question?
There you saw it. That was a long clip filled with a lot of interesting stuff that you can sort of decipher and unpackage. But fundamentally what you saw here is that, you know, a witness who behaves like that fundamentally is their own worst enemy. They are perhaps going to be more willing to behave like that in a deposition because they really are insulated from critical opinion. They are superstars, megastars. They're used to hearing yes and being fawned over, always being the subject of interviews, for example, where reporters sort of are fawning over them and gathering information, and they are center stage, and they're famous, they're important, they're powerful. Now they're center stage in a deposition, but completely different format, mode of communication. And the lawyers taking the depositions can just let it move along like that and encourage almost the person to continue in that demeanor, and that's all great for the lawyer taking the deposition because it really destroys the other side's case, and Lil Wayne does not come off looking in a manner that he would no doubt want to come off appearing in front of a jury. That may be great to be that way on on YouTube or for your fan base or to show the world how upset you are, but that's your fan base, right? A jury of 12 people who never heard of you see that, they're going to have very different thoughts about what was going on. And so I think another example that comes out of that is the importance of lawyers. Once you've prepared a witness, and if you have concerns, or even if you don't after preparation because you think it's fine, but if you know you're dealing with personalities who could fall into that, you want a letter to them protecting yourself so that the case doesn't get destroyed on your watch due to your lack of work preparing the client. Now, we're going to shift to, from the witnesses to the lawyers, and the lawyer's decorum to others. And this sort of echoes the quote we put in the beginning of the program from a court in terms of the growing and ever-growing judicial intolerance of ill behavior between lawyers and the decorum between lawyers in terms of how they behave and what we are allowed to do or not allowed to do in a deposition. And the general rule and expectation, of course, is both from rules of professional responsibility, the idea that we're officers of the court, we're involved in the legal system, is that we need to behave in a civil, professional, above-board manner. This is not a schoolyard, playground where we engage in brawls and fights with cursing and yelling and screaming and inappropriate behavior. And so that idea of we are a profession and we should behave as professionals requires a certain muzzling, in other words, of us and our behavior. And so let's take a look now at this next slide. This is one of lawyers insulting other lawyers. And I want you to look at it, keeping an eye out with respect to the lawyers and the dialogue between the two lawyers, especially the objecting lawyer. And we will then come back and talk about that in a minute.
Thanks for telling me the questions I should ask. Will have your opportunity at the end.
Just shut up and move on with your questions, okay?
Mr. Curry.
Just shut up, or I'll adjourn this deposition, and you can tell it to the judge, or I'll get you some tissues and you can cry.
Mr. Curry.
All right?
Please don't tell me what to do.
You
with this
asked him
deposition.
if he ever spoke with Farsh about anything. He said no. Now you're asking him to tell you what Farsh told him. It is a bullshit question. It is absolutely speculative, no foundation or anything else. Now, he's entitled to a fair question. You told him that. So if you're going to sit there and ask unfair questions, I'm going to correct them. So I don't waste this guy's time having to come back or go to trial and undo the mess that you're trying to create. Got me?
Are you finished?
Are you finished?
Are you
Do
aware
you
of-
understand the question,
Are
Mr.
you aware
Schiff?
of the local rules
Mr.
with
Foster?
regard to what objections you are allowed to make and what
Do
you're
you
not?
understand the question, Mr. Foster?
Sir, right now this is my witness. I get to ask the questions. You get to make objections only. There are two types of
Call the
objections
bailiff.
you can make. Objections
Call
to
the
form.
bailiff.
Sir.
Do you understand the question you're being asked, Mr. Foster?
Mr. Curry,
Don't ever presume that you get to tell me what to do or when to do it, counsel. Don't you ever presume.
Why
Mr.
should you
Foster,
be
this is
entitled-
your deposition. Do you understand the question?
why should you be entitled to then tell me what to do? Doesn't it go both ways?
Because I'm being straight with the guy and you're being not straight with the guy. That's why. He has no dog in this fight.
Are you finished giving your opinions now about
He
the
has no
question?
dog in this fight, and you're trying to get him to say things that are simply untrue. It's an old trick, Mr. Zohar.
You don't think you're
Okay.
trying to coach the witness right now?
I'm telling him what the question is so he can answer it.
Do you know what speaking objections are?
Don't lecture me, idiot. I'm telling you I'm not gonna let that happen. Okay? You got me? Do
I
we
wanna
understand
know
each other?
if you understand the
Are we
rules.
connecting here? Because
I'm
if we're
trying
not
to
connecting
proceed.
here, I will try again. Okay? Don't give me local rules, don't give me procedures, don't give me professionalism. Just put a fair question to the witness. And if you're not going to do that, then I am. We understand each other?
If you believe that a question that I ask is not proper, then you get to pose a valid objection. You're not allowed to make speaking objections. You're not allowed to give your
Don't lecture me,
opinions.
puppy. Don't lecture me. I was doing this when you were still chasing cheerleaders. Don't you even think about lecturing me about depositions.
I think you're practicing a few
So-
years more than me, actually.
so-
That's it,
so-
to be honest with you.
Do you understand the question?
Mr. Curry?
So there you saw, that's theater at its best. If there's a video clip in this whole program today, other than perhaps the very first one, this would be right up there with it for the Nobel Prize of deposition disaster theater at its best. Here we had the lawyer saying, "Shut up. Do you need tissues so you can stop crying?" A lawyer cursing, calling the other lawyer an idiot, even telling the lawyer, "You're a puppy and you were chasing cheerleaders when I was practicing law." We even had words and verbiage and tone, at least, that bordered on what I think, in my opinion, would be, close to threat type behavior, stuff about, don't ever presume with me, that kind of angry tone. Are we understanding each other in that tone of voice? It's very aggressive, and it's the type of thing that will provoke courts to issue sanctions, in my experience at least. And I think it's the type of thing that we can look at and recognize will not ultimately advance a client's case. If there's a problem with the questions, one can object. And if the questions really have problems and the lawyer doesn't fix the questions, then your objections will win the day and the testimony won't come in anyway. I mean, if lawyers are asking genuinely stupid, vague, irrelevant questions, well, then you're later on going to make your objection vague. And if it's irrelevant, you need to say that. You can object at trial. And if they try to then put that testimony in, you'll go tell the judge, "Judge, the question was vague. Look how vague it is. No one understood what it means. I told him, he didn't fix it. He's out of luck." And the court will say, "Yeah, you're out of luck. You don't get to put that in. You, the lawyer taking the deposition, didn't get your record." It doesn't require the lawyer defending to even engage in this to advance their case. Instead, what it does is damage the case. Now, the flip side to this is, how do you, as a lawyer taking a deposition, what do you do when you're dealing with this aggressive counsel? We've all dealt with it, and we try to keep our cool. Sometimes we don't. We get frustrated and we engage in a dialogue. And I think what you saw there was a lawyer who was no doubt shocked at sort of the demeanor and the tone and the aggression coming from the other side. And the lawyer doing that then, felt this need, we all do. When we're threatened, we get up in a corner and we want to fight back, and he felt that. And so he then is engaged on the record in this back and forth dialogue about the propriety of the objections, the merit of the objections. And that dialogue and that back and forth, where now you have lawyer talking to lawyer, you're getting nowhere. You're burning your clock and your time with the witness. You saw the witness just sitting there, almost smirking, wondering what was going on. And the lawyer now has been sidetracked from his role of being focused on the witness to get the information he wants from the witness, and the lawyer now has shifted, and he's now in an argument with the objecting lawyer. He's now getting worked up and upset, and that's all damaging the questioner's state of mind that should be centrally focused on the lawyer. And so the best advice, I think, here is when you get that behavior from a lawyer that's that inappropriate, let him make his objections, ignore him, keep going with your questions. Ignore him, ignore him, ignore him. Make him a potted plant, ignore him, get what you need. He can yell and scream all he wants. Don't engage back, because then some judge is going to look at the transcript and say, oh, poxy on all of you, and poxy on all your houses, you're all engaging in a war, and then you end up don't even getting anything out of it. Stay focused on the witness, make him a potted plant, ignore him, and then you can go to court and deal with his objections, especially if they become instructions not to answer, and you can deal with that in front of a judge on a motion to compel. That's, I think, the best advice, and it's very difficult. I'm not faulting that lawyer. Myself, when dealing with lawyers, like that in that clip, have often engaged in a back and forth about the impropriety of the nature of the objections being made, and sometimes you just engage in that discussion. But you want to make sure, if you are going to do it, you never lose central focus of what you're there to do. And so I really do think the best advice that I was given when I was trained as a young lawyer is to make the objecting lawyer a potted plant. Eyes focused on the witness, ignore him, let him say what he wants to say for the record, but you're focused dead ahead on the witness. Best way to deal with it. That, I think, though, was a good example of some theater at its best. Now let's look at another example of a deposition where it's really just gone off the rails. And this is an example of the difficulty of a lawyer who's also the witness in the case. And so the lawyer knows about objections and knows about the rules of evidence, but the lawyer isn't actually the lawyer in the case. He's now the party. And he has a lawyer sitting next to him representing him. So you have really two lawyers, one of whom's a lawyer witness. So let's watch these clips.
Mr. Abrams, we're going to be here for a long time today if you do not answer my questions. I just want to let you know that right now.
Object to form.
And put that on the record. Mr. Sullenberger, I'm sorry.
Stop laughing at my lawyer.
This is bizarre.
Stop laughing at my lawyer and stop harassing us.
Listen,
you brought us down here for fraud. Ask us fraud questions.
Mr. Abrams, how many times has your firm been added as a defendant in any lawsuit?
As I can recall, one in the Bieber matter.
So the Bieber matter and then this matter as well? Those are the only two times you recall that your firm has been added as a defendant?
Yes, as I recall.
Aside from traffic tickets, have you ever been named in a criminal action?
Object to form.
Object to form and privilege, so I assert privilege and need not answer.
What privilege are you asserting, sir?
Attorney-client privilege, and we would, under the law, I need not answer that.
What law are you referring to, Mr. Abrams?
I need a law book. And I moved to strike, and I moved for, I moved to strike the question. I refused to answer under privilege, and
Mr. Abrams, have you ever been arrested?
Object to form and privilege, attorney-client.
That's it? And you're instructing your client not to answer that question on the basis of attorney-client privilege, Mr. Sullenberger?
It's my understanding that Mr. Abrams had an attorney for any issues that may have arisen, and therefore he can assert.
I also don't recall being arrested.
What part of my question asked for any attorney-client privilege?
He's not being deposed.
I don't have to. I objected. I objected to form. I objected for privilege for Mr. Abrams.
I am going to end this deposition now.
Okay.
Mr. Abrams, we're going to continue it while we seek intervention of the special master.
Fine.
It's clear that you are not here to answer any questions
It's clear that
today,
you're harassing us.
and you are refusing to answer any
We've answered
questions
every question,
today.
read every question back.
Yeah, you have not.
We disagree.
Okay, let's ask a couple more questions. Mr. Abrams, what are the pills that you just took?
Object to form.
None of your business.
Privilege.
What are those other pills?
Object to privilege.
None of your business.
Medical privilege.
Mr. Abrams, are you under any any drugs today? Have you taken any drugs before you came to this deposition today?
No.
Okay. Have you taken any alcohol before you came to this deposition today?
No.
Any medication whatsoever?
No.
No. Just these pills that you're taking here?
Yes.
That you are refusing to answer what they are?
Yes.
Medical
None
privilege.
of your business.
Mm-hmm. Okay.
But I can tell you that if you took some of these, they would help get some of your weight off. I can tell you that.
Oh, you're referring to when you called me fat when you walked in here.
Objective form.
You don't recall that? Okay. Well, we have a couple of witnesses to that, including Mr. Sullenberger. In any event...
If you want to raise your weight problem, Mr. Ward, with the jury and with the special master, please do. But we're not the ones that are sitting here in that condition.
So there you saw a couple clips of what were really a remarkable back and forth between the lawyers. You had all the lawyers fighting. You had the witness literally objecting, which is inappropriate for a party witness, obviously, to be making objections. That's the witness's lawyer's job. And the lawyer's role is just getting blurred there completely. You had assertion of the privilege by people in ways that were confusing and didn't even make any sense. And then you ultimately ended up with the witness, who was also a lawyer, insulting the lawyer taking the question by insulting him for being fat or overweight, all of which looks horrendous. There is no way that entire exchange could possibly look good to a judge when it all gets put before a judge on a motion to compel. Everyone knows the judge is going to freak out and sanction people. It could never advance your cause. So the lawyer being interviewed or deposed there obviously was immensely frustrated, angered. He felt the case against him was BS and all that. But that's the type of thing that one defends in a different way. And so it's a good example of how lawyers, we prepare witnesses, but when we are our own witness, we have to prepare ourselves, or we have to listen to the advice of others. It's the same way doctors don't practice surgery on themselves. We should be loath to practice law for ourselves or family members because those lines get blurred and it gets confusing. Similar thing here. When we are lawyers as witnesses, we want to be really careful that we put on the witness hat, take off our lawyer hat, let our lawyer who we've hired represent us, and we remember that we're a party who's going to be before a jury, and we want to understand how any of this stuff could look to the jury or the judge, and it could just never look good to insult someone for being fat. Just never going to go over well. Now let's shift to the I don't recall disasters, and this is the issue of witnesses who say I don't recall, I don't know too much. And for those of you who are litigators, you all know how this unfolds. You may have even had experiences with it, but witnesses are always prepared by lawyers to listen carefully to the question and to answer it. Yes, no, and if you don't know, say, I don't know, I don't recall, if you really don't know. And that's sort of the thing that's drilled into witnesses by lawyers, because lawyers don't want witnesses to guess. We don't want you to speculate. We don't want you to guess. We don't want you to assume or give an answer yes because you presume it must be yes when you don't know it's yes, right? And so we drill that into people. And sometimes the lesson gets, in that drilling process, there's some filtering thing that goes wrong and the message gets contorted and twisted in terms of witness. And I'll tell you a funny one I had. Early in my career, I had prepared my witness about, listen very carefully to the question, make sure you understand it, only answer it if you understand it. If you don't understand the question, you can say, I don't understand the question, can you repeat it? And so the very first question in the deposition of my client was, can you tell us your name for the record, please? And my client did this. I don't know what you're asking. Are you asking for my first name, my middle name, or my surname? I kid you not, and I just thought to myself, oh my goodness, this is going to be a long day, and it was a long day. I had to take multiple breaks to explain that is not what we are talking about in terms of how one doesn't understand a question. And this over-literal interpretation of the idea can itself become a boomerang with certain people who don't have a right kind of relevancy filter for what the question and the idea is about. And so let's take a look at this clip. This is another one. It's only about 50 seconds on this clip, but this is an example of what's really a disastrous result when things go down this way. So let's watch it.
And you haven't attended college since 2005, as I understand it?
Correct.
When in 2005?
Don't recall.
Did you go to the spring semester?
I don't recall.
Don't recall whether you went to the fall semester?
Don't recall.
When did you produce your last movie?
I don't recall.
produce a movie in 2005?
I don't recall.
Did you produce a movie in 2004?
I don't recall.
No idea?
No.
What movies have you produced in the last 3 years?
I don't recall.
Have you produced one movie in the last 3 years?
I don't remember.
You don't remember whether
That's
you
what
produced a movie in the last 3 years?
That's what I told you a couple seconds ago when you asked me.
Yeah.
I said I don't remember.
You don't remember?
No, busy days, long hours.
Uh-huh.
It affects remembering everything.
It affects your memory.
Correct.
So there you saw what I think you could say is only a disastrous looking clip there in terms of a witness who simply is not recalling anything and everything that obviously could be recalled. And what often happens in depositions, and this is sort of the give and the take in depositions, is witnesses are prepared to say that, witnesses get frustrated. And the lawyer taking the deposition, who's in control of this format of dialogue, and this is what's so important about it, sees that. And a witness then starts getting defiant, and you saw there this sort of defiant rhythm where the witness was now irritated by the lawyer, who knows what happened before, and the witness kind of felt like, okay, F you, right? That's kind of the mindset. It's this defiant, thing. And so he's saying, I don't recall. Lawyer's going, okay, let's keep going. You don't recall? You don't recall? Throwing out questions, I don't recall, I don't recall, I don't recall. The lawyer's now got him in a rhythm of not recalling stuff. The witness is now irritated, angered, defiant. He's just saying, I don't recall a lot. And he's feeling pretty good. I don't recall, I don't recall. But what's going on is the lawyer taking it is getting a fantastic record of someone who ultimately will look like they lack credibility. I mean, the idea that you can't recall any information about all of those basic questions, it seemed to go to the core of the business or the production business issue at stake. It's not credible or believable. And so what that telegraphs, and the way the lawyer can then use that later, is what that telegraphs is witness wasn't being honest. And if he's not being honest about that, he's not being honest about this, or he's not being honest about this, that's bad for a case. And so it's an example of how the use of I don't recall can be overused in a way that doesn't work. And that may have been a witness who got tricked into doing that, and then that pattern of communication that was going on, that kind of defiant witness was egged on by the lawyer taking the questions, and now you've got a witness who's creating a terrible record for himself. It's no win-win there. And now on the next slide, we're going to look at some more of where we almost started, and that's Justin Bieber Revisited. This is part 2 with some I don't knows and I don't recalls. So let's take a watch and gander at this.
Remember earlier today when I asked you?
No.
Why don't you listen to what I had to say first? And then maybe you'll tell me yes or no.
I don't have to listen to anything you have to say.
Clarify my question. If you have a question about my question,
today is not
you have the right to be clear for you to be able to be clear. Do you remember being in Australia ever?
I don't know if I've been to Australia. I've been to Australia?
Are you aware that Scooter Braun knows that your bodyguards have attacked photographers?
What objection to form?
What kind of question is that? That didn't make sense.
That's correct.
That doesn't make sense. That's a weird question. That doesn't make sense.
Can you just ask some foundation?
I didn't hear your response. Again, sir, I'm
I didn't finish.
Oh, I'm sorry. I don't want to interrupt.
Oh, really? You didn't want to interrupt.
Is it true that you know that your security guards will punch, grab, and push Paps if they need to?
I object.
Would you please look at the film that's up there? Go ahead and start.
This is a film?
Please, sir.
This is a film?
Pause it. Would you please watch the television?
You said it's a film. You said watch the film. Is this a film?
Is there a difference between a film and something else?
Yes.
So yes or no answer required, right?
I think my lawyer's asking a question.
Please, sir.
I think my lawyer's asking a question.
I'm not here to answer his questions. You're here to answer mine. Have you ever disciplined Mr. Hesney?
Disciplined? What kind of question is that? Is he my son? Guess what? Guess what? I don't recall.
Am I going off the video record or does that?
So there you saw, again, a whole bunch of things in that clip that were quite good, but you saw the use there towards the end of I don't recall in this really petulant, probably is a way to put it. You can probably all think of much better adjectives than me in terms of how you interpreted that. But it really was a witness who was laughing and mocking the questioner about not recalling anything and feeling great about being able to say, I don't recall, I don't recall, I don't recall, making a joke of it, right? That will not look good before a judge. That, who knows what those, relevance of those questions were ultimately to the trial, but if that case went to trial and Justin Bieber would put on the witness stand and then, gets impeached with those clips, jury's going to see this guy sitting at trial who probably by then would be well behaved, all of a sudden in the deposition behaving that way, and the jury's going to understand, yeah, there's a disconnect, right? I mean, it doesn't work. And so again, it goes to the importance of witnesses who may lack control because of sort of where and how they live in our socioeconomic system, need a heck of a lot of preparation. After watching those clips, let's talk about sanctions now, because all of that stuff can filter into the realm of sanctions and sanction standards. And so the rules that set the groundwork for sanctions are that lawyers have to conduct the examination and cross-examination of a deponent in the same manner and with the same level of decorum as they would do at trial. So if you're going to behave like that at trial, you can behave like that in a depo. But if you know you're never going to do that at trial, you better not do it in a depo, right? That's the sort of big picture idea here. And failures to follow these rules can lead to sanctions, of attorney's fees and expenses by people who are impeding, delaying, or frustrating the examination of the deponent. Sanctions can follow for argumentative objections, suggestive objections, and directions not to answer. You see there, that's just a prototypical case, Craig versus St. Anthony's Medical Center from the 8th Circuit, prototypical case. Let's now on the next slide look at an actual case. This is from the 7th Circuit, and we're going to talk specifically about sanctions in terms of how things can go wrong in deposition disasters and the broad reach of sanctions. Redwood versus Dobson, 476 F. 3rd, 462 from the 7th Circuit in 2007. Here we have a lawyer taking the deposition and asking largely irrelevant and at times harassing questions. The defending lawyer, frustrated, did not suspend the depo to go get a protective order and instead engaged in speaking objections and improperly instructed the witness not to answer. So the deponent, who was himself a lawyer, it's not that case clip we saw earlier, but this is another example of a deponent being a lawyer, feigned the inability to remember or understand basic questions. The trial court then looked at the whole thing and said, you're all engaged in misconduct, you all behave badly, so I'm not going to sanction either side. But what happened when this went up on appeal by one of those unhappy lawyers who wanted to get the other side sanctioned but not get sanctioned himself? The 7th Circuit got it and reversed, saying, mutual enmity does not excuse a breakdown in the decorum, and the district court should have used its authority to maintain standards of civility and professionalism. The court then censured 3 lawyers, including the deponent. The taking, the defending, lawyer, witness, all get censured, admonished a 4th lawyer who was present, and warned any repetition of this performance in any court within this circuit will lead to sterner sanctions, including suspension or disbarment. So now on the next slide, you see this concept, nationwide cases are legion on this point now. We have 3 cases here of imposing sanctions for inappropriate, burdensome objections, speaking objections that obstructed the depo, abusive, unprofessional, and obstructive conduct during a deposition. These are just sort of prototypical things everywhere. And so now, sanctions analysis, and we're getting to the end here. And I think we should end where we began. That first clip probably is our Oscar winner today. Let's watch it again so we can unpackage it a little bit and ponder who would get sanctioned in this scenario if you put this before a court given these principles we've looked at.
Did you talk to this man sitting next to you before this deposition started?
Yesterday, but he had nothing to do
I
with
didn't
what
ask
you
you
are
that.
currently saying. I said it though, didn't I?
Did you talk to him, sir? What did you say?
I said nothing. I said you have a case of incipient verbal diarrhea.
Oh, sir, we're going to see about that.
Well, good.
Did you talk to him yesterday?
Yes.
How long?
About 3 hours.
Talk about this case?
Yes.
Did you tell him the other companies you consulted for?
No.
You're under oath here.
I did not.
We'll see about it. When you were at Monsanto, what was your title?
At Monsanto, what do you mean?
In Texas City.
Research chemist.
And was that your title during your entire stay at Texas City?
Texas City, yes.
Don't talk over each other.
After you left Texas City...
Wait a minute, let me ask a question here.
Yeah.
Do you represent this guy or not?
Who are you?
My name's Tucker, and I represent Ayrshire, and I just want to know, do you represent the guy or not? I'm getting, if you don't represent him, you don't have any right to be making any objection. If you do represent him, tell us so.
Why don't you keep your mouth shut and I'll do what I want.
No, you're not going to do what you want.
Oh, wait.
Do what I want.
No, you're
No,
not.
you're not.
Yeah, I am.
That's
I'm going to make
bullshit.
whatever objections I want to make, and I'll make them as loud as I want to make them. Or you just shut your mouth and we'll keep the record straight.
Don't tell me to shut my mouth, boy. You may be big, but you want to see how bad you are? Come on.
And I wouldn't try that, Ed.
Are you threatening to fight?
Hold on just a second.
Oh, I want to know whose side we're on. We're going to be outnumbered, Ed.
Hold on just a second.
No, you got a big mouth. Now you do. Now, you need to either represent the man or not.
I'm
I've tolerated
representing Monsanto, and I'm
But
making
you're
an
not-
objection on the record.
Then you're not entitled to be his lawyer then, okay?
I'm not representing the man.
Well,
I'm
you're
making
trying
an
to be.
objection on the
And
record.
another thing,
Don't tell
you
me what
don't.
I'm trying to do.
Yeah, I'm going to tell you something else. You don't run this deposition. You understand?
Neither do you, Joe.
You watch and see. You watch and see who does, big boy.
I'm telling you, Joe.
Oh, you ain't telling me a goddamn
I'm gonna make
thing.
whatever objections I want.
You can make your objections and keep quiet. See,
No,
but
I'm
don't be
not.
telling another lawyer to shut up.
Don't be
That
telling
ain't
me
your
to shut
goddamn
up.
job,
No, that's not
fat
your
boy.
job.
Now
Mr.
get back.
Hairpiece.
Now you got
As I said before, you have an incipient bad
What do you want to do about it, asshole?
Oh, I'd like to knock you on your
Well,
ass.
come
I'm
try
not
it.
gonna do
Wait a
that.
minute.
Come over here and try it,
Wait a
you
minute.
dumb son of a bitch.
Wait just a second.
Come over here.
Hold it. Hey, wait a minute. Hold on.
close.
No way.
Get
Hold on.
close.
Hold on.
When
Hold on just a second.
his associate are taking Mr. Garrett out in the hall to lecture him, I suppose. They're doing this over our objection. We started this deposition, unable to get an answer from this man.
So I think it's safe to say in that clip, if you watch it, and that's my all-time favorite, I've watched it many times on YouTube. You can find it on YouTube if you want to go watch it. If you watch it enough and unpackage it, in my mind at least, the conclusion I came to is that my gut tells me that if that was put before a judge by a sanctions motion, the judge would look at it and either do what that one court said, which is, you're all in trouble, I'm not sanctioning anyone, or would say, you're all getting sanctioned. I think it's the latter. And the Court of Appeals would probably get to the same place the Seventh Circuit did. Everyone was behaving inappropriately, down to even, personal insults, inappropriate objections, telling people they had no right to object when they were there as a party to the case, accusing people of, insulting people with pejorative sort of, personal slights about them and the way they physically appeared, even down to witnesses fighting and wanting to tee up and jump up towards the asking lawyer. So that one wins, takes the Oscar for me, and I think ultimately it would probably be everyone getting sanctioned in that one. Now, one final point here on sanctions is that there are sanctions for ill speech to other lawyers. And here's a couple examples where it's really important to look at, in a deposition, things that lawyers say that can be grossly inappropriate and definitely lead to sanctions. And so the first case here comes from the Northern District of California, where a lawyer in a deposition tells the other lawyer, a female lawyer, quote, "It's not becoming of a woman or an attorney who is acting professionally under the rules of professional responsibility," end quote. To have said the things you're saying in the deposition. Regardless of whatever she was saying, whether it was appropriate or not, that type of commentary and kind of improper put down and comment led to sanctions for sure. And then here's another one, and this is similar to some of even the clips we've seen and the quotes you saw in those videos. Statements to opposing counsel during a deposition such as, "Shame on you, someone apparently didn't fill you in on who you're dealing with here. It appears you might be hallucinating by positing the possibility that the defendants are going to win this lawsuit." Those types of comments lead to sanctions too. Just don't do it. That's the lesson. The final point is that you can actually be sanctioned as a lawyer for not controlling your witness. Your witness may go off the deep end and act inappropriately. We saw some videos of that today. You can be sanctioned. And so here we had a deponent who repeatedly refused to answer legit questions, who used a familiar four-letter word no fewer than 73 times on the record, and verbally accosted the lawyer taking the depo. And the court ultimately said, yeah, you witness are being sanctioned, but so is your lawyer. Your lawyer allowed this to go on, didn't control him, didn't do something to stop it, and you, the lawyer, defending that witness engaging that improper behavior, you're getting sanctioned too. So you have an obligation to curb that kind of client misconduct during a deposition that could, ultimately create those types of problems. Important point to keep in mind. You can't just sit as a potted plant to your own witness, letting them engage in that kind of ill behavior. So now we're at the end of our program. Our conclusions today, there are many. Big one is, you don't want to get caught on tape, but let's go through a few smaller ones. Depo prep for witnesses in video depots, and really all depots, but definitely if you're going to be on tape, it's critical. It's critical to explain how they're going to look at witnesses to a jury or to a judge if this is going to be the type of thing that's put before a judge on a motion to compel. Credibility in the case is huge. And credibility can be destroyed with bad video performances. These snippets, even if it's out of context for the way you behaved in the 8 hours, 2 or 3 minutes of inappropriate behavior, maybe like that one by Lil Wayne, that may have been 2 minutes out of 20 hours of deposition. But if that's the only 2 minutes you see, that's all you see. It can have a big impact. So one has to maintain the right demeanor all the time. Important point, don't engage in it and don't become a problem yourself. Don't let your witness's ill behavior become your problem. And don't get caught on tape like these folks did, because it could end up on YouTube like this, and you may find yourself in season 2 of the next series on this that we provide you. Thank you for watching, and if you have any questions, as ever, please email me.